So thank you. A warm welcome to everyone. I see new faces. Yeah, thank you so much. And people still entering the room, people also still joining us online. It's incredible the amount of attention that this event draws. It's really, really wonderful. And that's because of you three. I will get to that in a second. So my name is Lara Talsma. I am a PhD candidate here at the university for international and EU law. So this session will be recorded, the full bit, including the Q&A. If you object to any of that, you don't feel comfortable, just tell Alicia, who's in the corner, and we'll cut the Q&A session out. This event is hosted by SGEL, which is a research project called Sustainable Global Economic Law. It is a joint research project by 3 research groups based here at Amsterdam Law School: the Amsterdam Center for European Law and Governance, the Amsterdam Center for International Law, the Amsterdam Center for Transformative Private Law. Welcome, hi there. There they are, Center for Private Law. There's also a few more seats here in the front. So many thanks to SGEL and the centers for hosting this event, and especially Ivana Eselovic and Alicia van der Werf for all the background assistance and helping us get this event together. I want to keep my introduction as short as possible because I'm sure we have a lot of things to discuss. So I will straight away move to the speakers. First, of course, the star of the show today, literally, Dr. Emily Jones. She is a research fellow at Newcastle University under the Newcastle University academic track. She holds a PhD from SOAS University. Before joining Newcastle University, she was a senior lecturer at Essex Law School and the Human Rights Center of the University of Essex. And she's held several visiting positions, including at Melbourne Law School. In the last years, she's authored or co-authored several outstanding works, such as one of my favorites, The Law of War and Peace, Gender Analysis. But today we'll be discussing another very important work, Feminist Theory and International Law, Posthuman Perspectives. And although she already published it early 2023, this is the first time that Emily will be having a book event or an event around her book in person. So we are especially grateful that you will be doing this with us today. So thank you for that. Then one of our other panelists, Professor Hilary Charlesworth, hardly needs any introduction. She's currently a judge at the International Court of Justice, but a longtime brilliant academic in international law. And I'm sure for many of us in the room and online, she shifted our thinking of international law through her scholarship and her feminist scholarship. She has such an impressive and important record that I will not even get started, but it is an immense honor that you're with us here today. It's really, really our pleasure. So tremendous thanks for being with us and taking the time from your very, very busy schedule as we are all sort of following what's happening at the court these days. Thank you for that. And then, of course, Margaretha Wewerinke-Singh is our Associate Professor of Sustainability Law here at the Amsterdam Law School. From her impressive record, I will only highlight a few things, especially relevant for the purposes of today's discussion. In her work, she explores the role of law in transitioning to sustainable societies. And she's just completing her Veni Grant project called Climate Justice Through the Courts. She has several publications in the pipeline through that research project, so keep an eye out for those. And also Margaretha embodies the bridge between theory and practice. which is an important thread in Emily's work, in Emily's book as well. So again, thank you so much for being here. Thank you for hosting, and let's get straight to it, Emily.
All right, I'll just turn this on. Great. Well, thank you so much, Lara, for that introduction and for organising everything. And yeah, thank you to our panelists for being here today as well and agreeing to join us and engaging with my work. And thank you all for coming. As Lara said, this is my first in-person book event. I've been very ill this year. I've been going through chemotherapy treatment. So I was diagnosed with cancer just over a year ago. And so I haven't been able to do anything in person. I had a great online book launch, but you know, it's not quite the same. You kind of finish and you're at home and you're like, oh, woohoo, by yourself. So yeah, it's really, really good to be here and with so many people that familiar faces and people whose work I've read, etc. So thank you so much for coming, and to everybody online as well. Yeah, and special thanks also to Lara and Alicia for organising everything, and to the Sustainable Global Economic Law group, because you know, obviously I'm still in treatment, so travelling was quite difficult, and they really kind of put a lot in place to make it possible for me to be here today. So a really good example of equality in action. So thank you very much for that. I don't want to take up too much time because I want to hear from our panelists. I want to hear from all of you. But given that we're kind of focusing somewhat on 2 chapters of the book today, I just wanted to give a bit of an overview of the main arguments and kind of what else I say in the book. And then we can kind of go from there. And we have lots of time for discussion, I know, as well. So this book started off as my PhD thesis originally. And the idea behind that was that I wanted to rethink the structure of international law. So, you know, quite small, as you do as a PhD at the start. And the knowledge project that underlies international law through feminist theory. So that was the starting point. The idea came from my frustration, both from my master's degree, but also from my work experience in women's rights, which is what I did before starting the PhD, with the way that the law is just really set up around male needs and male knowledge. And at the same time, though, I was also seeing more and more books being published about women's rights, which was really, really good to see. But I had a sense that some of the kind of really groundbreaking ideas in Hilary's work with Christine Chinkin and Shelley Wright and others in kind of feminist approaches to international law in the sort of 80s and 90s, that work that really moved beyond a kind of analysis of international law and women's lives, but looked at general issues of international law, like sources, like treaties, like the state, kind of had a sense that that was being left behind in this focus on women's rights. Now, of course, there have always been people that are doing that important work, and we can think of Gina Heathcote, Diane Otto, Ratna Kapoor, Karen Knopp, Anne Orford, Eureka Ottoma. I could go on and on. But these voices were being seen as less central in feminist approaches to international law, where the focus really had come to be on women's rights and women's participation. So that work, of course, is really important. I'm not dismissing the work on women's rights and participation, and that's vitally important, and I use it throughout the book. But at the same time, I had a sense that we also needed to retain that focus on the core issues of international law. And I felt this was necessary not only to keep the momentum going, but also because, you know, that I was keen to say something to show that feminist approaches had more to say. They weren't just about kind of women's issues and, okay, so we need to look at women's lives, so we bring the feminists in now. But actually, feminist epistemology can speak back to all areas of international law. So this is kind of the starting point of the book, really, that feminist approaches to international law have been mischaracterized by the mainstream of the discipline as being a niche field that pertains only to women's lived experiences and their participation in decision-making processes. And so given this, the book seeks to exemplify how feminist approaches can be used to analyse all areas of international law. Of course, I don't analyse all areas, I have specific focus, but that's kind of the premise. And to do this, I use posthuman feminism. So I should probably explain what that is, because that's not necessarily a given. It's not, you know, one of these terms that not everyone will necessarily be familiar with. But I came across posthuman feminism actually through attending Rosie Brodotti's summer school, and she's here today, which is lovely, in Utrecht. So the Netherlands is a strong connection in this book as well. And I kind of actually went to Rosie's summer school I was kind of reading more feminist psychoanalysis, some queer theory, some post-colonial studies. And I went to Rosie's summer school because of her amazing work on feminism and obviously her strong reputation in that field. But through that summer school and through Rosie, I learned about posthuman feminism. And that kind of changed the whole PhD. So posthuman feminism, as I said, not an easy term. You might not have all heard of it, or posthumanism, etc. So I should probably, as I said, define that. There's lots of strands of posthuman theory now. It's a very well-established field, and I see some people in the audience that I know are posthuman studies people as well, so I don't want to get this wrong. But the way that I define posthuman feminism in my work and in the book is a body of work that seeks to dismantle exclusionary humanism, so challenging structures such as gender, race, class, ableism, while also rethinking anthropocentrism. So this idea that humans sit in hierarchy over the non-human. So including non-human animals and the environment, as we'll discuss in more detail today, but also technology, which is another focus in the book. I really look at regulation of military technologies as well. So the book therefore uses posthuman feminism, which I've defined, to analyse various topics in international law that seemingly have little to do with women's lived experiences. And these topics, as I mentioned, include military technologies, but also the conceptualization of the sovereign state in international law, modes of legal personality, and as we'll discuss in more detail today, international environmental law. So the book seeks to showcase how feminist theory through posthuman feminism can analyze all of these areas of international law. So that feminist epistemologies are actually central to all international lawyers, and you should all be reading them if you're an international lawyer. Not everyone is in here, but yeah. So the other main aim of the book, however, was to speak back to posthuman theory, which that's a body of scholarship that primarily sits within the humanities, and it hasn't always been so good at being applied. So there are some exceptions to this, particularly in the realm of pedagogies and art practice. There's some amazing people that are doing really great applied work there. But overall, it's been quite a theoretical project. So I also wanted to take that and my love of this body of work and think, well, what could we do to kind of apply it in practice, grounding it through the law? So the book is therefore theoretical, of course, because it's about posthuman feminism, so you probably guessed that. But I also really tried to make some concrete proposals for legal change. So how can posthuman feminism be used to design the law in a different way? And this is probably particularly the case in chapter 3 on military technologies and artificial intelligence, but it's a kind of really core theme throughout the book. So this is arguably a big tension, what feminist international lawyers Zoe Pearson and Sari Kuvo call resistance and compliance. You know, this tension between how do we resist international law and the kind of gendered, colonial, Eurocentric, ableist, classist system that it is. But then how should we work within that? So complying with that system and kind of working within that knowledge project, or is it better to sit outside of that and kind of challenge it from the outside? And in the book, I kind of straddle those positions in multiple different ways. Sometimes I kind of lean more on the compliance side, sometimes more on the resistance side, and kind of talk about how it changes depending on what you're looking at as well. But it's an important tension because there's a kind of a question, is international law inherently such a gendered knowledge project that actually we need to just kind of throw it away and think about something else and recreate it? Or can we actually transform it from within? And this is a really, really important question for feminists working in international law and for all critical scholars, I think. So I discussed this throughout the book and yeah, kind of really asked that question that whether international law can really be framed around the needs of what Ratner Kapoor calls the peripheral subjects, the kind of subjects that are not the mainstream of international law, not the white, male, heterosexual, middle-class subject, able-bodied as well. So I'm sure this is a theme that will come out in the conversation today, and I think it's one that probably many in this room are constantly thinking about and straddling. But I kind of want to leave it there because I want to hear from the rest of our fabulous panelists. And as we said, we want to really hear from all of you as well. So yeah, just to say thank you so much for being here, everyone. And thank you to all the people online too. I don't want to forget them. People dialing in from Australia, I see. So in the middle of the night, which is amazing. I feel very loved. So yeah, thank you very much.
Thank you, Lara, and thank you very much for bringing us together. And it's a huge pleasure to see Emily again and to meet Margaretha for the first time, but it's great to be back here at the University of Amsterdam. Well, I was just saying to Emily, I think I first met her, even though I feel a good friend of hers, I think in actual fact, we've met very little. This is the new life that we lead. But I did meet her first when she was a PhD student, and I was struck then by her generosity of character and mind, and her willingness to think beyond the law. And then a great pleasure of my academic life was a chance to work with Emily and her supervisor, Gina Heathcote, in producing an intergenerational conversation about the future of feminism, which came out in Feminist Legal Studies. And I was the grandmother. Gina was the mother, and Emily was their child. But I think she's overtaking us all. But I can just say that this book, and I just have it in PDF form, but that's probably illegal or something to have it, but it's a really exciting and energizing book. So I can just say, apart from anything else, it's a great read, and perhaps the rather serious title, it's a delight. It's an absolute delight to read, and it really well reflects, I think, Emily's engaging personality. So Emily set out, I won't tell you, she set out her basic arguments, but the thing that I thought was great and response to something I'm often asked was her claim is that, well, a gendered analysis, a feminist analysis can apply to any area of international law. And I think she does that magnificently. A question I was asked by someone not too long ago was, there can be a bit of a trick or a party game, if you like, that sometimes feminists are asked, like, tell me what is a feminist approach to topic X, and I was given continental shelf delimitation, and that was considered to be a knockdown. This will prove you feminists can say nothing at all, but you just have to look at Emily's book to get courage in such a task. So that will be my next job. So posthuman feminism, which I only understood sort of in a Wikipedia type of way until I read Emily's book. And but to me, it's one that's very productive and full of possibility. The idea that it's destabilizing hierarchies between humans, as Emily said, those of class, race, gender, ableism, but also the system that places humans above non-human phenomena, such as the environment and animals. And it's challenging the idea that humans are the primary actors in the moral world. So what's, to me, something that was fascinating, the idea that understanding human beings themselves as assemblages, and in Naya's words, co-evolving with other forms of life enmeshed with the environment and technology. So Emily certainly acknowledges the interesting strand, I think, in legal thinking that I'm very interested in about the materiality of law. But hers is, I think, a much more radical approach than a lot of the legal materialists, if I can call them that, because much post-human theorizing in law has really ignored feminist theory. So this idea of bringing together these two, one to me quite familiar way of thinking, introducing it with post-human theory has been very exciting. And what I was mainly struck by in reading the book was how exciting it was to see the way that Emily takes with great respect and affection the ideas of earlier generations of feminist international lawyers, so my generation, but transforms them into much more profound insights. So one thing that's very striking about the book is the broad theoretical range of Emily's reading. Just her footnotes are breathtaking. And But what's really wonderful is that the book remains really accessible. And I really thought such a fantastic project to try to adapt what might be seen as quite arcane theoretical ideas, but trying to think about them rather bravely and honestly, admitting the problems, introducing them into practice. So I was struck, at one stage in the book, Emily says her one of aim is to reform international law. And that isn't a fashionable goal at all of any critically minded international lawyer who would prefer to criticize and then leave it foundering at the side. But Emily is extremely brave. So, and this dilemma that she's already flagged that runs through the book, the dilemma of the inevitable oscillation between compliance with international law, whatever that is, but I take that to mean working within the system, and resistance, working outside the law and moving beyond legal regulation. So chapter 6 was where I found really intriguing, where she has a very honest reflection on being caught between in this oscillation. I think they're a model of reflexive scholarship. And she makes the point, she concludes with saying, well, resistance and compliance are hardly binaries. We shouldn't think of them in that way. And they do tend to be. I mean, even theorists are often put, you're either a practitioner or you're a theorist. So there's the refreshing honesty too in the way that her reform proposals on military technologies, she says, well, the first lot that she comes up with, while radical from the perspective of the current legal system, she said, and I'm using her words here, they ended up being far more conservative than I had initially hoped. So she acknowledges squarely that a legal approach required her to designate some military technologies as perfectly legal, while her feminist politics would call this into question. On the other hand, when Emily devises more speculative proposals informed by feminist posthumanism, including Indigenous approaches to artificial intelligence, she tells us, she admits honestly, she found it hard to remain within the normative framework of international law. So there's an interesting paradox she points to that, in fact, international law deals in non-human legal subjects readily and comfortably, such as states, international organizations. But when it comes to practice, it tends to be, in her phrase, all too human. In other words, protecting some human interests over others, indeed reinforcing inequality between humans, and often very short-term understandings of human life over and above the rights of non-human species and nature itself. So I really liked Emily's phrase that international law is stubbornly anthropocentric, and for her, in essence, objectifies non-humans and understands any harm to non-humans as the inevitable collateral damage of preserving human existence. So her two really, again, very honest and illuminating case studies of military technologies and international environmental law. And I'll leave Margaretha to talk about environmental law. But it was, as I say, the really intriguing thing is when Emily goes to try, for example, in the area of military technologies, consider the regulation of autonomous weapons systems. And she made, for me, what was a really full of insight, the point that much of the debate that we read in philosophical terms is quite misplaced, because it assumes that we can draw a dichotomy between military technology and the humans who use it, between humans and their machines. But this obscures the fact, as Emily points out consistently, that technology is already deeply implicated in many life and death decisions. So I profited a lot from Emily's explorations in the field of environmental law, of some of the standard legal vocabulary, such as sustainable development and the common heritage of humanity. I'm of the generation that remembers that these actually seemed like radical terms when they were introduced. That was seen as the cutting edge. But Emily quickly shows how much anthropomorphism they involve. So I was also, it's all these things that people like me are just catching up with, and then Emily tells us they're hopelessly compromised. But the right to a healthy environment, which is considered to be at the cutting edge of international human rights law. But she makes the point, and once you get into the groove of Emily's theoretical framework, this makes perfect sense. But of course, this is very limited by being confined to human rights, and certainly sets to one side the rights of animals or the rights of the environment itself. And even in chapter 5, where we get a very sympathetic account of the rights of nature movement, Emily makes the disarming point that it will lose its critical edge, that concept, if it comes in too close relationship with international law. So let me end just by saying that certainly I've often complained that mainstream international law scholars, whoever they are, tend to give desultory attention, if any, to feminist approaches. As best, feminist approaches are seen as this exotic anomaly to be referenced perhaps in one footnote in a weighty tone, if at all. And yet, for their part, feminist methodologies typically operate, to borrow Carol Smart's words, in a state of constant challenge and continual reformulation. So you have feminist methodologies constantly rethinking, debating themselves, and then you have, it's as though they're two entirely different streams, the mainstream of international law proceeding on in its stately way. And Carol Smart again has observed that feminist research has been, and these are her words, its own most trenchant critic. So all the interesting debate and I suppose controversy has been among feminists about feminist approaches, and it just seems the mainstream proceeds on. So one can think of a book Emily references, Janet Halley's well-known book, Split Decisions, How and Why to Take a Break from Feminism. So that's one example of some of this intra-feminist debate. But what's different about Emily's book to books such as Janet Halley's book is that the book is certainly critical, but to me, it makes a really significant contribution to feminist theorising in international law by modelling generosity and respect for other scholars. I think it's an astonishing tour de force in that respect. The book is also really an illuminating guide to posthuman feminism. Along with Donna Haraway, Emily presents posthumanism not just a way of approaching the law, but, and these are Haraway's words, an ethical position that extends moral concern to things that are different from us, and in particular to other species and objects with which we cohabit the world. In other words, a posthuman ethics encourages us to think outside of the interests of our own species, be less narcissistic in our conception of the world, and to take the interests and rights of things that are different to us seriously. But finally, the book is also a thought-provoking meditation on what are we doing as international lawyers. We have to accept the limited scope of our discipline for fostering fundamental change, and I think we have to be modest about what we can accomplish. But Emily leaves us with the hope that the most creative forms of compliance with international law will always be sparked by resistance or thinking against the law.
Add a few thoughts. So let me start by saying, Emily, that your book is a magical book. What you've done is nothing short of alchemy. And beware, because with that you're placing yourself in a tradition of dangerous women, women with special powers. And fear of such powers has been with us for centuries as well. As we know, the Bible, for one, has numerous remarks on witches and women who do magic, deserving death. Their blood shall be upon them, as per Leviticus 20:27. And as Ben Grossman has pointed out, exceptions are made by the big guy in the sky, but those apply mainly to men such as Moses. So what is magical about your book? So allow me to take you back to a point in my own life. I was an intellectually starved first generation student of philosophy at another Dutch university. And the curriculum had put me on a diet of the grand works of dead white male philosophers. Empty calories, still starving, because I was craving some deep thinking about how to address the big problems that were plaguing the world. Climate change, environmental degradation, inequality, racism, sexism, violence against all sorts of groups and animals and nature, and there was little on offer there. Then one Saturday afternoon, I found myself in the public library, and it was there that I found a copy of Rosie Guidotti's book, Nomadic Subjects.
Oh.
I picked it up and I started reading. I sat down on the floor, was kicked out of the library at closing time, still managed to check out the book, and I just didn't put it down until I had finished. And it was a feast. What is so different about your work, Rosie? That is so refreshing. It was so nourishing to myself as a student of philosophy at the time. So it's the brilliant confrontation of the traditional Western philosophy's focus on rationality, on universals, on dualisms. And so Rosie's nomadic theory decenters the humanist subject, as posthuman studies do, and sees identities as multiple, fluid, complex assemblages. And so it offers a critique of hierarchies and power structures, so important. At any time, it seemed so relevant to the present times, and affirming at the same time, affirming difference. So offering a critique that can do away with the kind of homogenizing tendencies that much other that exist in humanism, but also very much in environmental movements. And we all live in the Anthropocene, we're all responsible, we're all affected, we're on the same boat. So difference, and focusing on relations and on becoming, so very dynamic. And so this really opens new vistas that are centered on life, on the body, and on affirmative ethics. And so affirmative ethics, and forgive me, Rosie, if I'm mischaracterizing your work, I'm trying to distill it to what I have perceived to be its core. So it's about capacitating ourselves and our world through creative ethical practice that starts from a place of wonder, of generative power, and transformative visions of the future. So this is an ethics that is supremely suited to our complex and also technologically mediated and ecologically desperate times. So this in itself is already bold. But as you said, Emily, that this body of work, and of course, Rosie is very much like you, Emily, a very generous scholar who explicitly builds on an enormous range of works by sisters and others who have paved the way. So there's a lot of gold out there, and so this was there. But what have you done, Emily? So that is really and explaining the relevance of this work to international law for the very first time. And so to me, as somebody who has been reading this work for a considerable amount of time, it was always clear that this work is offers extremely potent material to critique international law, but I didn't even dare try. And instead, so I personally went more into practice, trying to do what you, Emily, in your book call changing international law from within. And so I remain interested in theories, but often found them still quite detached from the actual practice. And so what you have done is really uniquely showing how feminist posthumanism can challenge I think the most fundamental problems of international law, including its anthropocentrism. And then some others have done that too, but you go further by also drawing on the capacity of this theory to center the difference and relationality and situatedness, and also how queering international law can help us account of difference. And so, of course, you don't just remain in the theoretical realm or in the critiquing mode, but also show how this perspective can bring about transformational shifts, overcoming the limitations of legal liberalism and humanism, and at the same time also recognizing the tensions that you then face, the compliance, resistance, or inside-outside dilemma that constantly emerges. But I think the point that we are talking about a continuum there is really critical, and that is also why I think we shouldn't be too alarmed when we reach the end of the book, we read that we may need to just dispose of international law altogether. That sounds quite drastic, but then again, I think we're reminded that the whole point of affirmative ethics is also to not necessarily take an end goal and then put yourself just on the road to then focus on the goal, but rather always you're becoming. It is the transformational process itself that actually matters most. And so in that sense, these dichotomies aren't too problematic at all. And so then just a few final thoughts on where this leaves us, or it could leave us. So the what do we do further with these insights? So we've seen that some insights that seem from a feminist post-human perspective very promising, including recognition of rights of nature and granting legal personality to parts of nature, still have limitations because they need to be fit within the framework of neoliberal legal systems, and at the same time all promise because they themselves may have a transformational impact on those systems. And a very important point that you highlight in the final chapter and then also in the conclusion is the importance of relationality, and then relationality can be contrasted with rights being more subject-oriented notion, and relationality being a mode of being, perhaps even a mode of practice that holds potential for more transformational kinds of changes, and could perhaps even be translated into further legal reforms, perhaps more away from rights towards relationality. And to get us started on thinking that through further, I wanted to get back to the insight of nature and culture not being a dichotomy either, but also a continuum, really important insight, because as you highlight, we need that insight to avoid the trap of reducing everything to nature, which has had so many adverse implications already for women and also for other groups in the periphery. So this continuum is also helpful, I think, for understanding how we can take these ideas forward, because international law is material. So and of course there's this whole body of important scholarship on that as well, the materiality or the practice of international, what is physical about it, so what happens at courts, but also on the street where people are protesting sometimes on behalf of other life forms, such as the movement now on Turtle Islands, on wild rice, where people are advocating on behalf of wild rice against certain ecologically destructive practices. So this kind of really physical resistance against some of the structures that constitute international law at present. And then on the other hand, the cultural or perhaps normative aspects of international law, where there's also room for transformation, which can be incremental. And it's here that rights of nature and similar ideas can also help to achieve some of that transformation from within. And I also see a lot of potential in cultural rights here, which are often also a way of bringing in very different perspectives and epistemologies. So the Human Rights Committee's views on the Bailey versus Australia case is a good example of a case where that has, to some extent at least, happened. And of course, the Inter-American Court of Human Rights has a rich body of jurisprudence as well, indigenous rights, where a lot of inspiration can be drawn from using existing legal frameworks that are not radical at all, and at least to some extent transforming them to accommodate different views and also relationships. So I'll leave it here and very much look forward to hearing from people who, because we have a wonderfully diverse group of colleagues and scholars with us.
Thank you so much for those reflections. Maybe we can take a few more minutes for you to respond to each other as well before we open the floor for questions and comments, and perhaps dive into what was already mentioned, the issue of between resistance and compliance, because we have here at the table, we have theory and we have people working in practice. And the thread of your book is also that you try to bridge the theory and the practice. So perhaps Margaretha already mentioned a few examples, but perhaps in conversation you could expand on that a bit more. With your research in climate litigation before the courts, and perhaps both of your experiences also with rethinking and reimagining court cases through the Feminist Judgment Project, and perhaps also your work in the court as far as you're able to draw on that, of course. Where do you see, if we stay within the law, where do you see room for using the theories that you've expanded upon in your book, and where do you see perhaps developments in practice where that relates to these theories that are perhaps inspired by these theories?
I guess I should probably start. First of all, thank you so much both for those wonderfully generous responses to the book. And I feel like you've summarized everything much better than I could actually. So that was really lovely to hear. I guess to think about your question, Lara, I mean, I think we've all touched on it a bit in relation to the book. I think the main thing for me, this dichotomy between resistance and compliance, as I said, is not really necessarily a dichotomy. And I think that's a key thing in the book. You know, you can be resisting within international law. And I think actually international environmental law is a really key site for that. And we can think of lots of kind of amazing resistance movements within international environmental law. But likewise, and as Hilary touched on in relation to my chapter on military technologies, there I kind of came up against kind of, well, we can use international law to potentially make the regulation of military technologies better, but ultimately a kind of feminist ethics of disarmament, and there's a long history of disarmament in terms of feminist approaches to international law, in the end, it just kind of makes you complicit with that system. You're still saying that some technologies that kill are okay because they're slightly more ethical than these ones, so that's fine. And so in the end, I kind of concluded in that chapter that maybe there can't be a kind of a feminist approach to this. You know, I looked at data feminism, I looked at indigenous approaches to AI, kind of critical disability approaches, you know, people that are looking at design of artificial intelligence and technology said, oh, could we apply them in this sphere? But in the end, it's like, no, because it's just so much fundamentally against a feminist ethics. And so I think those two examples are quite useful because, you know, one has a kind of much more hopeful moment, whereas the other one in some ways doesn't. And it makes us think about those tensions between resistance and compliance in different ways. But yeah, I'll stop there because we have two actual practitioners here. So I'll give the floor to them.
I can just say I find it funny that I would be told I'm a practitioner. It's funny, perhaps we all see ourselves in different ways, but when I think of practitioner, I think of my completely miserable years when I used to go to a law firm and sit at a desk there and issue debt notices. That's what I think of as practice. So I think that it's funny. I actually see the job of the judge as highly theoretical, and in a sense, certainly what the so yes, there's a practicality perhaps because a decision will affect you're presented with an actual situation, but one only has to look at any judgment of the International Court of Justice to see that they're highly theoretical, and the theoretical positions that are taken are exceptionally important. I'm always reminded of the words of one of my wonderful colleagues, John Braithwaite, a criminologist, who said, "There's nothing so practical as a good theory." And I often think that's the point. And people will often not own their theories. They will say, I'm a practical person, I would just like to say the following. But of course, everybody is starting from a theoretical position. So I feel compared with somebody who seriously knows about litigation and how to plan it and to go into court, I feel I don't deserve that title. So I just wanted to say that's how I respond to that. I think that I think mainstream international lawyers, for a large part, I expect if one asked any of the people who practice before the court, famous advocates, if you said, what is your theoretical position on international law? I'm sure most would be startled and just say, I don't have one. I don't have a theoretical position. I just know the law and I'll come into court and I'll argue for its application. But it seems to me it's very important. It's a very important move to have to reflect what is my theoretical position. And I've always thought as soon as you have a label like a feminist international lawyer, you're considered, your theory has been named. You've got a colour, that's your theory. And but it's important, to recognise that even the most practical or apparently practical practitioners are all operating from a theoretical position. And the danger is it doesn't have to be displayed or debated or subject to critical scrutiny. I think that's the problem. It's just assumed, and the assumptions that it embodies never actually come to the surface.
Yeah, I guess I'm one of those lawyers guilty of saying that they are just practitioners or scholars, but not theorists. So even though I actually have a background in philosophy, even not even completely disingenuous declarations have always been that my theory is at home and I'm here doing law. But of course, law is theoretical to a large extent, and even doctrinal work is theoretical to a significant extent. And then, for me, I think it's a tension that I still grapple with. So when and where do you bring in theory? Because it does bring about a risk of marginalization. Because then you admit that you are operating outside of the confines of law as such, and so in practice, you wouldn't want to be accused of not actually presenting the law. In legal arguments, it matters tremendously whether what you say is a legal argument or theoretical one. A legal argument will have more force. And then again, if in terms of perhaps positive examples, just mentioning a snippet of experience, that is that recently, a few months ago, we were in Hamburg for the hearings in the advisory proceedings before the International Tribunal of the Sea on climate change, for the advisory opinion that had been requested by the Commission on Small Island States on Climate Change and International Law. And the Attorney General of Vanuatu took the floor, and he delivered a speech that was not a legal speech at all. It was a setting the stage speech. And in that speech, he talked about the Vanuatu people's relationship to their environment, and even the use of English is limited, so nobody could express. But what he was talking about is that for Vanuatu peoples, it was obvious that nature needed to be treated with respect, and then nature would also in turn respect the people. Very simple point, but it was made and it landed well, it seems. And then what I found intriguing is that the representative of New Zealand in her speech, which was a legal speech, it spoke to the question that the tribunal had been asked to answer. She drew in this remark that the Attorney General had made and noted that this ethic that was expressed in that simple statement was also very much present in the ethics of the Maori people in New Zealand, the indigenous people in New Zealand. But there was a kinship there, and therefore New Zealand considered this to be a very important point that it wished to reiterate and also underline its importance to the legal question that was before the court. So she drew this factual statement into the normative realm, and that was really significant for a range of reasons. One being that this also constituted a shift in New Zealand's position, because on the papers, in the written stage of the proceedings, New Zealand's position had been quite conservative and unhelpful because of the small island state, generalizing a little bit. But there was certainly a shift visible where the position had become, during the hearings, more constructive and helpful. And that is, I think, a relationality that was at play there, that has roots in the indigenous connections in the region, and that played out there at the level of legal practice at an international judicial body in Hamburg, between people who were there, who had listened to each other. And so it is, you in your book speak about deep listening being a very important part of achieving this kind of transformation, and I think that was a key there. And of course, you're talking about very incremental changes, but I do think these small incremental changes that are the result of this example of listening and openness are very important.
Great, thanks so much for these reflections. A lot of food for thought. I want to open the floor for questions and comments. I see hands. Also online, do feel free to ask questions either by raising your hand through the button or by putting your question in the chat. And also, please, if you ask a question, please could you turn on your camera if that's at all possible so that we see who we're talking to. Ivani, you want to go first? I saw your hand first.
Thank you so much for this wonderful conversation. Ivani-Singh, I work on gender and law here, and I co-lead the Sustainable Global Economic Law Project. So thank you for being here. I want to go back, refocus on your book a little bit, and then has question more broadly on feminism and what that means in legal scholarship. So I was wondering if you could maybe explain a little bit more, so you did it during your presentation, but what does the focus on post-human feminism add to the conversation within feminism? So how is this different than queer feminism that you also elaborate on in your book? What does that add to materialist feminism? How is it different, right? Where are the convergences, where are the divergences? If you could tell us more about that. And then I had two questions for the panel, I guess. One is about feminist practices within academia, right? So it is clear, listening to you, that it's not only deploying this or that theory, however sophisticated that might be, but there's also something about doing scholarship in a certain way. And I was wondering if you could reflect on that. And finally, another question related to that is the erasure of feminism in legal academia. Emily, you touched upon that, Hilary, Charlesworth too, of course. So I was wondering if you could perhaps reflect on what has changed, what has changed since your article, landmark article in 1991, right? Where do you see changes? Where do you see resistance? And what explains the multiple forms of erasures that we still see going on, erasure or marginalization or attempts to discredit it, as you mentioned at the beginning of your talk. Thank you so much.
Yeah, go.
Wow, so many questions, thank you, and so many complicated questions as well. I guess, so I'll start with the first one. So yeah, what does the focus on post-human feminism really add to feminism, and I guess feminism in law, international law as well? I think for me, what post-human feminism really added was, well, first of all, most feminist theory these days, thankfully, focuses on intersectionality. So there's already that strand of thinking about class and about, race, etc., within most feminist thought. But what I think post-human feminism adds to that for me is then that focus on the kind of non-human element, and also bringing those things together. And this is kind of what a lot of queer post-human theories also do, which I discuss in the book and which you touched on as well, Lana. Like really kind of focusing on how those inequalities are actually really tethered together. So the queer subject in many ways has been dehumanized. Lots of human subjects, racialized subjects, have been dehumanized. And queer theories of the non-human argue that maybe they have more in common with animals than they do with the white man. And kind of thinking through in that sense, I think is really important. And I think that's what post-human feminism for me adds to feminism. I guess it's also bringing Marxism, it's bringing class, it's bringing race, etc. together, and that's a strength with the kind of post-anthropocentric. Could also be, in some senses, a weakness, because in the end, you end up bringing so many things together that it feels like sometimes I can't quite do everything justice. I try my best to, but I think that maybe, for example, I look at Marxist approaches in the book, but I would have liked to do a lot more and doing it in other work. But yeah, I think that's maybe difficult with sort of interdisciplinary work as well, and work that's looking at multiple intersections of oppression. Should I move on to the other questions? Is that all right? Yeah, okay. So feminist approaches to international law and how to kind of do feminist scholarship. I This is a great question for me because I'm very proud to say that I have so many feminist international lawyers that have supported me over the years. And I actually think that that is really unique to feminists working in international law. Like, they're a really amazing group of people. Like, if you're an early career scholar and you're thinking about like, where am I going to situate myself? If you want like a friendly group of people that are just going to be so supportive and so kind, people like Hilary and Christine and Diotto and all of so many different people, Ratna Kapoor, like they're just a great group of people. And I think that's also that generosity, I hope, kind of comes through in the book. I try to, as Hilary said, I really try to kind of think through multiple different people's ideas in a kind of generative way. I'm kind of not, I think there can be a turn sometimes in critical theory to just kind of, oh, I'm going to destroy this person and that's the end. And I'm just not that interested in that. I think maybe I'm a bit too optimistic and believe in a better world. So that's what I try and do. And I think that feminists have inspired me to do that because I think feminists do believe in a better world and they help one another to co-create that world. So I think that that's kind of my answer to that one. Marginalization of feminist approaches to international law and what has changed. I mean, I think Hilary will probably have a lot more to say on this than me. Seeing as she founded Feminist Approach to International Law with Christine Chinkin and Shelley Wright. But yeah, I mean, I guess at this stage, I feel like most international lawyers recognize that it's a thing that they should know about and they should include, but they don't necessarily do it. Or as Hilary said, they'll put like one footnote to like, normally to Hilary and Christine, to be honest. Great work, but there's obviously a lot of other people that write on these things as well. I think part of that is fear. I think sometimes people are frightened of actually properly engaging with feminist approach to international law, maybe especially men. So I think that's part of it. But as I said, I also think that feminist approaches are seen as like that kind of niche thing where we have the women in the corner that are doing the women's issues, and we don't need to worry about that because they're doing that, and that's cool. And we'll put one of them on a panel, maybe, if you're lucky, or we'll have them in another, we'll have a separate feminist panel and they can all go and talk amongst each other. But actually, that's what I'm trying to do with this book, is to say, actually, all of you should be reading Feminist Approaches to International Law because they challenge the way that we think. So I think, sadly, I mean, of course, Hilary has done multiple kind of critiques of this and of the marginalization of feminist approaches. I think it's still happening, but hopefully we can change that. We'll see. So I'll hand over to the others.
Yeah, I guess I'll just make one remark on erasing feminism, and I'm not even trying to be provocative when saying that. I think it's because there's also fear that feminism is dangerous, because in the end, feminism at its most, when at its most potent, really challenges these violent, oppressive systems of power, of which international law, unfortunately, to a large extent, still forms part. At a very deep fundamental way, and would also not accept anything less than transformational change. So that is threatening. And I think therefore this marginalization is can be seen as political and is to be taken also very seriously. And so all the more power to you, Emily, for really driving this point home that feminism belongs at the heart of it all, at all of these struggles, and then that bridges to the point about doing feminism. That solidarity is, I think, for many of us the key word, and that's also again how how we can basically fight this marginalization or erasure and really ensure that in the end justice prevails.
Yes, thank you. There are a lot of questions. I'll just pick up on one. The changes since, say, 1991. What I've seen, and I think that in many ways, you know, there has been progress. I would just want to say that that I think it's difficult now but it's going to be in particular fields to ignore the situation of women. So you notice, for example, that the UN special rapporteurs, the country ones, and on specific themes, they generally will be much more attentive or much more open to considering women. But it's also, there is an element of the add women and stir to that. I recall, you know, back when we wrote that article, when we were looking at some, for example, of the special rapporteurs who were focusing on places like Afghanistan, they would produce reports that simply never spoke about the situation of women. I think today that would be different. So we celebrate that. And again, Emily refers to this in her book. There are themes such as Resolution 1325, the Security Council resolution, Women, Peace and Security, which give prominence to some of these issues, but they are in limited areas. And even when they're considered, women, peace and security as an idea, I think has been corralled. It's very, very limited, and it's yet to have none of its radical potential, I think, has been exploited. So it's just been fenced off a bit. So I think there still remains, I think it's as if the vocabulary has become quite widespread, and women, gender is often sort of produced. But I think, generally speaking, the discipline of international law has, for a number of reasons, I think, been unwilling to think through the much more thoroughgoing, what a thoroughgoing engagement with feminism would mean. And that's what is really, as Margaretha has said, that's what's, I think, so exciting about Emily's book, in that I would say you're quite fearless, Emily, in taking topics that have been really the province of a particular type of specialist international lawyer, and really saying, I'm going to show you how we could think this through. And a question I was going to have for Emily related to this is, we've got people of all different levels of academic life here, maybe you could talk a bit about what techniques would you advise or have you found useful when you're picking up a new field? Like if let me give you my challenge of continental shelf communication. You don't have to answer that. but I think it'd be really wonderful, given that you've grappled with these things. What techniques do you use when you're confronted with this area that at first sight people say, oh, there's nothing about gender in that? So that's I'd like to hand back to you in that respect.
Thank you both. It's a very difficult question in some ways. I guess what it made me think of is when I was at the University of Essex, someone said to me, a colleague, oh, yeah, I said, I'm writing about international environmental law. They were like, oh, well, you can't do that because you don't do international environmental law. And I was like, oh, well, actually, it was in my PhD and I do. And, and like, years later, I think that people actually recognize me as working in international environmental law. So, haha, I'll show you. But I think that it is difficult, isn't it? Because these kind of bodies of law, international law and all law is made complicated on purpose, because that's to exclude people from understanding it so that lawyers can make money, really, in the end. And I think what is really difficult when you're trying to look at these mainstream issues of international law, there is so much out there and it's so specialized, and we talk about the fragmentation of international law, how everybody has a specialist discipline. So someone might be working on human rights and they know everything about that, but they don't know anything about statehood. And it is really daunting. For me, I actually tend to start by reading textbooks. If I'm like, you know what, I really want to look at delimitation issues. That would be a really difficult one because it's so technical. But I think it's really good to start with just reading textbooks like we did in our undergraduate. That's how I often begin, and then from there, like reading the critical scholarship. But I think it's really important to feel like you know the law first before you critique it, which I mean, I think that sounds kind of almost obvious, but doesn't always happen. I think in international law, I think you really have to put in the time to do that. And also, you know, getting people to read your work. I'm so lucky that, I mean, if you look at the acknowledgements in my book, so many people read different chapters of my book. People who are specialists in those different fields, where I was like, oh, I'm not sure that I've got international humanitarian law completely right, and somebody would check that for me and that, you know, read it through and give me comments, and I think that that's really important, that kind of drawing on the generosity of other scholars, feminists and other critical voices, and actually sometimes some doctrinal people have been very generous too, so not to kind of uphold that binary either. So I think that's kind of how I seek to do it, but it can be very daunting as well at the same time. Feminist approaches to delimitation of the continental shelf is one that you can work on, I think.
Great, any more questions? Maybe yes. Okay, I'll start with Eliana and then Andrea and then you. I don't think I have anyone online, right? No.
Hello, thank you so much. I'm really excited to have you all here, and especially Emily, who has been a good friend and for many years. And I just wanted to say this book really reflects very much, I think, Emily's nature, the generosity, the thoughtfulness, but also the optimism in a way. And but also I think I wanted to ask you, Emily, maybe to explain a bit something that Hilary mentioned in her remarks about your decision really to write this book in a very accessible way. And you actually mentioned that yourself in the book. And I was wondering how this relates to your ethics of caring. Also, really, this can be seen a form of practicing in itself. So the decision to take seriously your role as a legal scholar, and so, and also your privilege in a way as a legal scholar, and also as a way to disrupting certain hierarchies, right, within in knowledge. So I know you made that as a conscious decision, and maybe you could say something about that. And then another question is, I also think this is somehow a hopeful book, as also Margaretha mentioned, and despite the critique, the very compelling critique. And so I wanted to ask you and everyone else, where do you see hope? And also, how do you understand hope, right? In a way that reflects that tension that you so well address in your book about really resistance and compliance. So, yeah, what do you think? Yeah. Thanks very much. It's brilliant.
Should we take these next two questions first and then answer? Andrea?
Well, also from me, Emily, wonderful to see you. Thank you very much for coming. It's a great pleasure to see this. And I just want to also say that indeed, the book was astonishing in the sense that it was so accessible. So I think your exposition of different concepts and what is at stake, thinking through them, why transhumanism, not posthumanism, different, how do they, what are we talking about? I find it really extremely helpful and beautiful, and can't wait to use it for teaching. So it's wonderful. So I want to take advantage also a bit of the opportunity of having you here to say in your own words, in your own thinking about ethics, about an affirmative ethics. In a sense, I think what you show in the book is that posthumanist feminism has shown you a way of delineating differently. No, it's not the binary, it's not the binary cut that we go with. But I think that then now, when you spoke about the two different areas, the military technology versus the rights of nature, to a certain degree, you know, you dare to say, and I love that you dare to say, here no, but here yes maybe. And so I would like to ask you a bit of, in this theory apparatus that comes together between posthumanist feminism and the very deep reading of legal theory, what comes out in the mix of those two that allows you to do delineation, maybe not the delimitation of the continental shelf, but delineations in general of like how to think about this, yes, no, here maybe not, like what is in the weeds there?
Yeah, your question. Sorry, I don't know your name. Go ahead.
I'm Mans. My name is Mansa. I'd have two questions actually. The first is for Emily. And So something I was wondering when I was reading a book and also listening to you was how do you think post-human approach, especially feminism, really aligns with approaches which are very human-centric? And what I'm thinking of is SGEL, where human equality is tied so strongly to nation-based inequality. And in this case, do you think post-humanism adds to it? Do you think it applies here? And how do you think the intersectionality of it really comes into play? And my second question is rather general and actually something that came up today in today's discussion. And today you spoke about how practitioners sometimes have certain approaches, have certain ethics, and some maybe they don't. And I was wondering for future practitioners out there, is there a danger to align yourself strongly with an approach, from a very practical point of view? Does it detract from defending a certain point of law? Yeah.
I'll quickly take Ingo's question and then I have to give the floor to you.
Okay, I'll try and remember.
Yeah, yeah.
Thanks so much also from my side, Emily, and co-panelist Margaretha, Hilary, for this wonderful session. So I think it's maybe not yet mainstream, right? But I hope that environmental and social forces will put it there before long. My question connects to Liana's point about hope, and I would like to take also the opportunity here to ask you if you could tease out a bit more of the answer if the overall question is about transformation, because transformation seems to get, if I overstate it a little bit, lost between compliance and resistance, because I would imagine the transformation to be a transformation towards a different law, right? A non-anthropocentric, a non-patriarchal, a non-capitalist, a non-bourgeois kind of law. But how would you think about that transformation that is, I can't imagine how it would come about either through compliance or resistance. Thanks.
Yeah, go ahead, I go first then.
Wow. Thank you so much, everybody, for those wonderful questions. Okay, so I'll start with Eliana, then I'll probably link to Eliana and Ingo together, and we'll go from there, and then Manta, Andrea. Eliana, thank you so much for noting that I tried my best to write in an accessible way, and Hilary mentioned this, and some of you have as well. That was really, really important to me. I think partly because sometimes theory can also be pretty inaccessible, and I didn't want it to be inaccessible. I wanted a student or an international lawyer who is practicing to be able to kind of pick up the book and find something for them in there. And I guess this was a bit of a decision because arguably language itself is deeply humanist and anthropocentric. And I think sometimes I kind of use language in a way that could be critiqued for being that. Because I'm trying to make it very accessible. So, if you read other kind of post-human studies works, sometimes people use very poetic language and it's very beautifully written, but it's quite hard to kind of understand actually what they're saying unless you're very much in that world. And I wanted this to be something that's really accessible. So it's a way of disrupting hierarchies and just kind of, I don't think that possibly my mum tried to read it and didn't really understand everything, but tried her best. But so it's not necessarily I haven't achieved accessibility completely, but I've tried my best. And I think that that's politically really important to me. In terms of how I see hope, and bringing in also Ingo's question with Eliana's and kind of transformation. So this is kind of a reflection that comes throughout the book. How can we imagine another law entirely, whilst also kind of, recognizing, for example, if you look at human rights, women's rights was really important because, actually human rights were set up around male needs before, and women didn't have rights. So I don't want to just say, working within the law is completely pointless, because that's just not true either. In terms of my kind of theory of hope, and this is something I've actually been thinking about a lot lately, so it's a nice question. I draw a lot of inspiration actually from queer theory in this. So Jose Esteban Munoz in particular is someone whose work I really, really love. So he kind of does a lot of kind of cultural studies, performance art, post-colonial queer work. And he really talks about how for queer theory, hope and kind of the queer blueprint is something that you never quite reach. So it's kind of, and you don't know exactly what it is, but you're always just slowly reaching towards it. And of course, that can be lots of different things. I mean, it can be very small incremental change. So I talk in the book, you know, maybe to some extent, recognizing the rights of nature more on the global level could be a really important step. At the same time, there are limitations to that, as we were discussing before. You know, rights are very individual kind of things in international law. They've been widely critiqued by feminist and post-colonial and Marxist scholars. So what happens when we bring rights of nature into that existing framework? But I think it's kind of about thinking strategically on multiple levels. And that's what I really try to do in the book, is to kind of, I guess I have this vision of hope that is based on challenging all of these models of oppression. And I try to reach towards them in different ways, sometimes more successfully than others. But yeah, I think it's important to also recognize that working within the system of international law can be really, really important. And Margaretha also spoke about some of the ongoing climate change cases, the ITLOS tribunal and the sea level rise. And of course, we have ongoing case at the ICJ as well on climate change. These are really important. These are led by small island developing states. And we're starting to see also more and more global south and small island developing states using international law for their own argumentation and what they want, which I think is like really amazing to see. And I can think of South Africa, Israel here as well, right? So yeah, that's kind of my answer, I think, on those questions. Andrea, affirmative ethics and kind of what comes out, that's such a challenging question and so complicated, and I would probably need so long to think about it. But yeah, you're right. I guess I kind of come with military technologies. I say, no, we can't engage a kind of feminist analysis of this in the end beyond disarmament, because it's just too complicated, and a feminist politics has always been disarmament. But with environment, I find a bit more hope. And I guess I kind of come to that through this post-human feminist framework and through also the history of feminist approaches to international law. You could argue that somewhat is arbitrary. It's what I think in the end, and I decide which ones. But you know, there isn't a fundamental ethics there that I think comes, as I said, from post-human feminism, from gender theory, from queer theory, from post-colonial theory, and that's kind of what informs it. But we could probably talk for a lot longer about that one. Is it Manta? Was that how? Mansak. Oh, Mansak. Sorry. Okay, I wrote that down wrong because I didn't hear you properly. Mansak. Okay. Yeah, thank you for that question about kind of human-centric critical theories, and especially TWAIL. I think that's like such an important one, because for me, a lot of post-human studies outside of law, but actually within law too, have kind of said, oh, we need to focus on the non-human, and that's really important, and how do we think about relationality and our entanglements, but they actually leave marginalized subjects behind in doing that. And what's been really important for me in this book is to be like, actually those things can be done together. So it's about bringing TWAIL with Marxism, with feminist theory, with kind of post-anthropocentric thought, and actually noting, you know, the environment in many ways, the international environmental law and the way that we see the environment as an object to be exploited, that comes from a colonial history, which, you know, colonialism was about exploiting peoples and their environments in the end. So those things have always been linked. So this is why I think post-human feminism does that in a way that post-humanism maybe doesn't in quite the same way, because it brings those different strands together, and I think that's really, really important. And I do use quite a lot of TWAIL work in the book as well. So, and yeah, your question about practitioners and is it dangerous to align yourself to a particular approach? Again, I think Hilary might have more to say on this. Yeah, I think potentially it is dangerous. I think sometimes, I mean, I find it interesting with, if you reflect on sort of Hilary and Christine Chinkin's careers, they've both done feminist work, but they've also done a lot of generalist work that isn't necessarily kind of explicitly feminist, but they often get associated with that. And I think that that's really interesting. Rather than saying like they're really good international lawyers, it's like, oh, they're the feminist international lawyers. And I think that that is a danger. You know, I've also published things that are not necessarily explicitly feminist. I mean, feminism informs everything I do in the end, but And I mean, it shouldn't be, and that's really unfair, but I think it can be. And I think the same can happen with Twale as well, for example. You can still secretly align yourself as well, though, which that's what I always teach my students. So when I was working at the University of Essex, we had a lot of students that would go and work in the UN in human rights. And I'd be like, don't forget your decolonial theory. Say you're really good at human rights, but have it in your mind. So I think that that's really important. I think I have answered all the questions. So yeah.
Just had a couple of things, and thanks, Hilary, for such rich answers. Just for Eliana, I'd say, I remember there's a wonderful piece in the Twale Review, I think the very first one. Do you know the one by Karen Nicholson? Yeah, and well, just for others, where she reflects, these are all freely available online. You can just sort of go online to get the Twale Review, and she has a nice reflection there on the difference between hope and optimism. And it's really nicely sort of thought through. So optimism is sort of a personality trait. She talks about hope at a much deeper level. And I also think hope can be, there are different ways that hope is mobilized in the context of international environmental law, perhaps sometimes in a very crude way, like what's everybody worrying about? It'll all be okay in the end. But of course, I think to have an interest in international law means that you're a hopeful sort of person. I would just say that it's to have an interest in something that at first seems highly unlikely, some sort of regulatory system that might respond over and above completely imperative of political expedience, I think implies that I think there's a fundamental hope right at the bottom of that. I just then come perhaps to the last question of this one about is there a danger in taking on a particular theoretical identity? I would say it's I don't know the danger. I mean, yes, I feel I have been typecast often, but on the other hand, I sort of don't regret that at all. And I would just say if you feel there's a theoretical position that really captures well for you where you are, I would just say wear it. You will find that that's not the only thing that you'll be judged on. So I would be perhaps, this is very surprising for me, to be slightly bolder than Emily, but I like that. I would say you don't have to do it secretly. I would just say, why not? Because life is short, and it's very hard to masquerade as an atheoretical, positivist international lawyer if your heart's not there. You'll be sussed out anyway. I would say I think it's really important if I mean there's no need to take on a persona. There's nothing, but I would just say it's certainly, it took me a long time actually to encounter feminist theories. That certainly wasn't something around when I was studying law, and I think that's added for me so much more engagement and interest in the field of international law. So I think that I would just warmly encourage you to leave aside the professional risks. I would say I think they're worth taking.
Let me just echo that one, because it's so important indeed. And in the end, I think for many, if not most of us, we are most convincing and effective and happy when we are true to ourselves and our beliefs. And so that I think very much includes also embracing ideas that we find compelling ourselves and valuable, and articulating them. And it is also a way of further creating and nourishing these networks of solidarity, which are so important to our projects. And then one more thing, Andrea, I really love your question because it is so difficult and so important. I think, this is one of the core questions that one encounters when engaging, especially I think with this kind of theory. So we understand that the ethics is affirmative, but where do you stop affirming? Where is there a point where enough is enough? And there, to an extent, sometimes perhaps you can then think about alchemy, about turning something bad into something good. But that is also sometimes just not possible. And so perhaps there's something to say about thinking about how close you are to what you know is the root of evil, to use a really strong word, of things that are really wrong in the world. And if you're getting really close to that, that may be a sign that there is a line to be drawn. And I think that is what you did, Emily, in your chapter on the military tech, exactly. And yeah, you probably didn't get that close yet in the environmental law chapters, though probably if you would have devoted a whole book to just international environmental law and would have gone in more depth into the market mechanisms and things like that, they didn't encounter land grabbing. That's probably then also you encounter places where you are going to draw that line. But of course, yeah, it remains a really important question. I think one that we can all apply more thoughts to very productively.
Thank you so much, everyone. Unless there are any very, very pressing questions, see no hands, I'd like to close it here. This was beautiful, very thoughtful questions as well. Thank you so much for your time and for being here, for sharing your thoughts so openly with us in solidarity. Let's have drinks outside, and thank you everyone for being online. Also, before I forget, I think this is potentially the best attended SGEL lecture that we may have ever had, sort of. Well, it is.
Say yes, because.
Please say yes. Well, I mean, we have an entirely full house. We moved to a bigger room, and we have so many people online. So I mean, yeah, it speaks to you, our panelists. It speaks to your book, and it speaks to hopefully feminism becoming mainstream.
Yeah.
On that positive, hopeful note, let's have some drinks.